Good morning, Mr. Will.
Good morning, Your Honor, and may it please the Court. My name is Dan Will from the law firm Devine Millimet in Manchester, New Hampshire, and I'm honored to be here today before you on behalf of the three appellants in these somewhat related appeals, CFM Buckley North, John Adams Nursing Home, and Longmeadow of Taunton.
Mr. Will, you can use your time any way you choose. It would be most helpful to me if you could focus on the trust argument piece of your argument.
Sure.
At least at some point during your argument.
I'd be happy to start there if you'd like.
Okay.
And if you had any specific questions, I'd be happy to lead off with those, or I can talk a little bit about.
I have a question.
Sure.
In the trust part of your argument, I must say I'm a little confused on how you deal with the occupied piece of that
Sure.
language.
And that's an argument that has been raised by appellees. The statute, I deal with it in two different ways. I think that there's a statutory construction-based argument that says that the occupied component doesn't apply to the in-trust piece. It applies to the owned piece, okay? And I think you could probably go, in all fairness and candor, I think you could probably go either way on that, but I think it's a legitimate argument, and the reason why I think it's legitimate, and in fact I think it's probably the better reading of the statute, is because it's the only way, I think, to make sense out of the Children's Hospital decision.
Except that there's language in that decision, I believe, where the court said, in fact, Children's was physically occupying that land while the laundry was being built.
Correct. Children's was occupying the land as of, I think, January 1, 1961, the date of the year that Children's was contesting. But it was holding it in trust for the association, and the association was not occupying the property during that time.
Okay, but Children's itself
Part of the association. Wasn't Children's part of the association?
It was ultimately, but it was also, I mean, until the association came into being, it itself, because it was a corporation, could sort of be part of the other part of the statute. But you're saying that the court really wasn't talking about that. I mean, I thought they were combining the two.
I understand. The way I read the Children's Hospital analysis there is that Children's occupied that property to the extent that it had two employees on the property at some point in 1961 making preparations.
Oh, I see. And that, the Chief Justice's question is Children's, but Children's is also part of the association, so in that sense the association is occupying it. Was that what you were suggesting?
That's not the way I read the Children's decision.
No, I was actually probably incorrectly doing it backwards. I mean, maybe yes, it was. Maybe at least somebody who was part of the association was. Yeah.
And it's a little bit confusing, but in fact, as the opinion reads, the association didn't even come into existence until
afterwards.
I want to say like March of that year or something like that, where Children's had been occupying the property in a at least nominal way. I think even prior to 1961. I think it took title in 1960 and had two employees there making the preparations. The association comes into existence. Certainly the association had been talked about, I think, among the hospital entities, but it certainly was not in
Chief
existence.
Justice Wilkins does say that the finding that Children's bought the real estate for the purpose of the laundry to be operated by itself or to hold as trustee for association seems conclusive. Right.
Conclusive in what sense? I'm sorry.
That's the end of the sentence.
To me, it's conclusive that Children's. The decision, I think, makes a little bit of your point.
But he then goes on to say, in our view, it is not important which it was.
Exactly.
So.
Exactly, but the decision certainly suggests that you could look at it either way. Children's indeed was holding that property in trust for the association, and ultimately, when you look at the way it played out, I think that's.
And then he goes on. I mean, you've read this opinion 100 times, I'm sure. I've only read it once. I've discovered a great deal of interesting factual data about how laundries operate. But he says if the realty was to be held in trust for association, it should fall within that express phrase in Section 5.
Exactly.
Okay.
And swinging back to your question, Justice Botsford, on the occupancy, the occupied aspect of that, statute. So if Children's was holding that property in trust, Children's was occupying that property, but the association was not. So I think that's my response, and that's why I think the statutory construction argument on the occupied that we've advanced, it really stems from that reading of Children's. The occupied piece doesn't really apply so much to the entity for whom the property is held in trust as much as it does to the entity holding the property. And that actually is consistent with the exemption kind of overall, which is, look, you can't buy property and just sort of hold it and do nothing with it and say, well, I'm holding it in trust for somebody, and 50 years from now they're going to take it, and so I should get the exemption. Really what you need to do in order to be entitled to the exemption is you need to be putting that property to work towards advancing the public good, towards a charitable purpose. And so I think that's why the occupied requirement, I think, reasonably attaches to the entity that's holding the property.
Why is that? Wouldn't it? Why doesn't that come out the other way? It should mean that the charitable organization for whom the property is being held is in fact occupying the property to further their charitable purposes.
I don't think that's the case. I think that the held in trust language, that property is held in trust for the advancement of the, call it the beneficiary organization's charitable purpose, to be sure. But that, I don't think, then follows that beneficiary entity is the entity to be occupying the property. And if you look at Children's Hospital, that's what was going on. The Laundry Association didn't occupy the property during that first year. In fact, the property for the entire year of 1961 was owned by Children's and held in trust basically for this association, which never occupied it during that time.
Could I get you to speak to the language of the statute, Section 5? Doesn't it require that there be a corporation, that it be incorporated?
I think that, I mean...
Isn't that what the words say?
What the word says is incorporated in the Commonwealth.
Yes.
And
a trust.
I'm sorry?
We're on the
Or
second.
a trust.
Sure, so we're not dealing with incorporated in the Commonwealth. I mean, I'm sure you want to get to that, but it's the trust for the benevolent, correct? You're relying on the second piece?
No.
Correct.
No, you're relying on the real estate piece. You're relying on the real estate piece.
Under both pieces of that statute.
Okay.
Correct. So in the first instance, the statute doesn't say expressly that the entity has to be a corporation, that it has to be a certain type of corporation. And as you look through the exemption statute more generally, Chapter 5, where corporate entity form matters, the legislature is very specific about that. So there's an exemption for in I think Clause 16 for corporations subject to taxation under Chapter 63, very specific form. Or in another section of the statute, there's an exemption that applies to domestic business corporations, which have a statutory definition. And so in those instances, you would absolutely have to read the legislation and the statute as requiring a corporation, not just a corporation, but a specific corporation. In Clause 3rd, the statute describes an entity that is incorporated in the Commonwealth. And actually what I think, in thinking about it just really this morning, I think part of that pertains to more to an interest in the legislature at the time of having it be a Massachusetts-based entity that would receive the exemption.
I take it that's unconstitutional.
That it was a corporation or not. And yes,
unconstitutional.
The Commonwealth piece of that is unconstitutional, correct.
But the incorporated isn't unconstitutional.
Right. I would have to concede that the incorporated piece is not unconstitutional, but I think that the clause that it's attached to maybe sheds some light on what the purpose of the phrase was. Now, it's true, and there are plenty of cases that talk about construing charitable exemptions strictly, no doubt about it. But as we pointed out in the Sullivan case, there's also some direction from this court that says, let's construe these exemptions reasonably in a way that furthers the legislative purpose. Let's not frustrate the legislative purpose through, our sort of strict interpretation. I'm paraphrasing. There's a quote from the Sullivan case, which we have in our brief. Out of that flows what has become to be known this functional approach to evaluating whether an organization falls within or without the parameters of the exemption. And I think that functional approach makes sense with the statute in terms of how it is set up internally within itself. Use of incorporated in Section 3rd, incorporated in the Commonwealth versus in other sections applying to a specific type of corporation. And I think that's an important distinction.
But if you're right, why wouldn't the charitable exemption extend to real property held in the name of a sole proprietor, a human being, who ran a nursing home on a nonprofit basis for charitable purposes?
And I don't have an easy answer to that. In part, I guess part of my answer would be those aren't the facts before us. I mean, an LLC is very close to a corporation in terms of function and form and operation and structure on the one hand. On the other hand, there's really nothing about the form between a corporation and LLC that really has any impact on the ability to carry out the charitable purposes. It could very well be that an individual, as you described, could make a persuasive case that he or she ought to be entitled to the exemption. On the other hand, I think an individual is much further from the overall definition of charitable organization in the statute than an LLC.
Now, an LLC, I take it, is not considered incorporated in Massachusetts for purposes of Massachusetts law.
Well, certainly in the LLC statute, it's described as an unincorporated association.
What about in Delaware? These are LLCs in Delaware. Is that also true in Delaware?
I believe that they are not considered corporations in Delaware, although in many instances in Delaware law they're treated as such.
Okay,
So it's a fine distinction. I don't think Delaware law views them sort of per se as corporations. On the other hand, I think that they're somewhat interchangeable in Delaware corporate law.
But you don't make the argument, I take it, that these Delaware LLCs are not, quote, incorporated for purposes of this statute.
You know, that we would look to the state of organization to figure out.
We did raise that argument in our reply brief, that to the extent that they're treated somewhat differently in Delaware law, that applies and is persuasive. Again, I don't want to overstate it and say that Delaware law treats LLCs as corporations.
Okay.
Could I ask you this question? Oh, I'm sorry.
Can I ask? Let's, for a moment, break this paragraph third down. There's part of it deals with personal property, right? Part of it deals with real estate. Yes? Am I right about that?
Correct.
With respect to the personal property part, are you saying that you are a trust under Section 2 of the third paragraph?
No, we are not.
Okay. So you're simply concluding, or you're arguing that you are a trust, or you're holding real estate in trust. Okay.
In trust for the
right.
charitable entity, Elder Trust.
Thank you. So you really have no claim to the personal property exemption, unless we conclude that you're a charitable organization.
And the claim that we would have to the personal property exemption would flow from this court's analysis of
Right.
what
But
incorporated
what's at
means.
issue here is real estate taxes, isn't it?
I'm sorry?
Isn't what's at issue here real estate taxes, or is it
It's
also
both, isn't
It's
it?
both?
It's really both, but real estate is the big.
Sure.
Yeah,
you know,
one
big
is
number.
one is $400. The personal is $400, and
Right. It's
the others are
Could
I
I
think
ask,
it's 7,000.
several thousand,
Yeah.
correct.
do you make, I think you do make an argument, but about, this is back in the real estate and holding in trust for. The officers of the three LLCs are exactly the same as of Elder Trust, correct?
Correct.
So is that part of your saying that this property is occupied by the officers, or do you not make that
Well,
argument?
I don't think that that's a proper reading of the occupied. The occupied piece I don't think means that your corporate officers, your headquarters have to be in the property. In the charitable exemption context, there's case law that says that, decisions I should say from this court that say what occupied really means is, I think, it's an active appropriation of the property for the charitable uses of the organization. So it's enough that there are charitable nursing homes in these properties. There's a case, I think, where it was enough that students were living in dorms at MIT. It's enough that a janitor was was using property at the Thayer Academy for those properties to be considered to be occupied by the entities that own them. So I don't make the argument that elder trust officers physically occupy.
Oh, no, I understand that, but it is, they are the ones who are, because they are also officers of the 3 nursing homes, they are the ones who are basically, at least legally, in charge of those operations.
In a sense, I think you're correct in that the LLCs are so closely bound to the mission and purpose of Elder Trust and so controlled by Elder Trust that I think that's true, but I also wouldn't want to blur the lines and suggest that they are not separate entities, because they are for corporate purposes.
And this is just, oh, you're over your time. Never mind.
It's fine, because I'm going to ask a question. Justice Botsford, do you want to ask a question? Mr. Will, this is not necessarily relevant, but what is given the cap on liability of charitable corporations in Massachusetts, what's the advantage of an LLC?
This
That was
isn't in
my
the
question.
record. It isn't in the record, but it's sort of tangentially in the record. If you look at the organizational documents for Elder Trust, which are in the appendix, part of what Elder Trust is empowered to do is seek to try to obtain financing for some of these projects through housing and urban development, HUD financing. What isn't in the record, but what I'll represent to you as far as I know, is that type of financing is pretty complex and exacting in terms of what it takes to obtain. And I believe that the LLC was created so that the entities would all be individually completely separate from Elder Trust as a requirement of HUD financing for each of the individual entities. So that I think so that if there were need at some point in time for recourse on that financing, there wouldn't be senior claims, and Elder Trust wouldn't have to be in the middle of that. But I don't have a lot of expertise on that, but my understanding is that that's why they were set up in this fashion.
Is that
initially.
the only structure that would have satisfied that complex financing arrangement?
I don't know the answer to that question. I believe that I can only say that the level of sophistication leads me to suggest that was a necessary structure.
One final question. Do you know whether there have been any challenges in other states? I mean, I recognize that the Massachusetts statute is a very particular statute, but on this point?
On this issue, we have not found anything. Now, in fairness, that isn't to say nothing is out there, but we've given it a good look and have not found a case that's...
And in other states, have these LLCs been treated as tax-exempt properties, exempt from real estate taxes, to the extent that you know?
I do not know.
Okay.
I have not found anything on that one way or the other.
Thank you,
Thank you
Mr.
very
Will.
much, Your Honors.
Ms. Crowley? Ms. Crowley, I should know the answer to this, and I don't right at the moment. Did we ask for amicus briefs in this case?
I don't believe it.
Okay,
I
thanks.
don't believe the court did. If it please the court, my name is Rosemary Crowley. I represent the Board of Assessors for the City of Taunton and the Town of Greenfield, and my sister, Janet Petkin, represents the Board of Assessors for the City of Quincy. And before I jump into the children's case, which I think you've identified the absolute nub of this case, I'd just like to step back and put this case in context. This is a charitable exemption, and this is a shifting of tax burden. So when these entities are excused from paying property tax, dollar for dollar, that tax burden is shifted back onto the citizens of our respective communities. So, in that context, this court has recognized that the legislature set out a bare statutory compliance that must be complied with, and further, that one of those requirements is incorporation. Now, plain and simple, that is a requirement to receive the exemption. It is not necessary to speculate why the legislature put in that strict requirement. However,
Can I just ask you, I understand all of that, and I don't want to,
Okay.
but I think you have to turn to, and real estate owned by or held in trust for a charitable organization.
Okay.
Okay, I mean,
I think-
because I understand that when you mean that a charitable organization shall mean a charitable or scientific incorporated, and now the in the Commonwealth piece is gone. But you've got the and real estate owned by or held in trust for a charitable organization. And here, for a charitable organization, the charitable organization is a charitable or scientific institution incorporated in some other place, right?
I think if you look at the children's decision and you concentrate on what troubled the court in that case, what troubled the court in that case was that Children's Hospital was the owner of that property for approximately a year plus. While Children's Hospital owned that property was not being used to render patient care, and that property was not being used to perform laundry services. It was a garage. It was in a very optimal location because it was proximate to the planned association of hospitals. The hospitals had been discussing combining laundry services for economies. What happened was this property came up for sale. And so Children's Hospital jumped in and bought the property. But the association, which they had talked about, had not been formed yet. So the hospital is holding it in trust. They bring in some architects. They start to work on how they will convert this garage into a laundry, which will serve the charitable purpose of the hospitals. So what this court held in Children's Hospital was, all right, while Children's Hospital was the owner and the association was not the owner, while Children's Hospital was the owner, they did occupy it. And we say that it occupied it for the purposes, for the charitable purposes of the hospital. It didn't actually render charitable services, but it advanced the ball. It put it in motion to convert this garage into a laundry. So I think what the court was saying in Children's Hospital is that phrase, held in trust, was put there for this situation.
Yes, but I understand that, and I certainly don't disagree with your summary of the decision in Children's Hospital. But that was one fact situation, right? I
Right.
mean, it's a real estate owned or held by or held in trust. I mean, there's nothing to suggest that Children's is the only such. And so what would be helpful to me is to say, why doesn't that apply to this situation? Because here it's conceded, right?
Mm-hmm.
I mean, I think it's conceded that the activity that is conducted on these three properties is charitable in nature. Whether or not they're entitled to a real estate exemption is different, but it's charitable in nature, correct? The operating of nursing homes for indigent and people on Medicare and Medicaid, and the elderly on Medicare, correct?
Well, the Appellate Tax Board reached its decision based solely on the fact that an LLC cannot qualify as a charitable
No, I understand
organization.
that, but
And the dominant purpose test has not been reached.
No,
And
the
nor
appellate tax-
applied.
that it
the-
would.
the tax board talked about it, said just that wasn't on this record.
The Appellate Tax Board, there was no evidentiary hearing in this case. This case comes to you in a judgment on the pleadings.
But I mean, I'm not making a factual finding up here, but certainly there are a lot of cases that say this kind of activity is charitable in nature. It's not for profit. It's charitable in nature.
It is charitable. The activity generically described is charitable in nature. It is the intention of the communities, should this court decide to send it back to the Appellate Tax Board, to assert that all three LLCs have failed the dominant purpose test. in that the dominant purpose is not a charitable purpose. Rather, the dominant purpose of these organizations is to provide a cash flow to a real estate investment trust.
And what, are you suggesting Elder Trust is a real estate investment trust?
No, I am not. There are two privately owned for-profit corporations that have notes to each of the LLCs, and one holds a note with a high interest rate.
I don't want to stop you. Is this in the record?
Excuse me?
All of the stuff is in the record, but in any case, we
This
should
is
be
not in the
careful
record.
to say.
This is
Yeah.
This is,
I just want to make clear that should you rule against us on this issue of law, which the Appellate Tax Board found as a matter of law, we're going to partition off this issue, it's dispositive, it's a matter of law, this is an LLC, it's not a charitable organization.
Okay.
So there is a second part to this case, but this case, this situation alone is dispositive. Going back, to get this property tax exemption, the first thing, and it's a jurisdictional requirement, the first thing an entity has to do is they have to file pursuant to Section 5, subsection B. They have to file their Form ABC, which is basically a yearly application they make for the exemption, the property exemption. And it is an affidavit stating that the property is owned by a charitable organization or a charitable organization, and that charitable organization is occupying the property for its charitable purposes. In these cases, it's the LLCs that applied for the exemption, that they filled out the forms. And it was represented on those forms that was 100% occupied by the owner. The owners on the deeds are the LLCs. And while this does seem to be hyper-technical, this is public trust. This is money that is being shifted back to the taxpayers. And in Brown-Rudnick, in Kirby, the court recognized there is a technical compliance element to these cases. There's a tax benefit being received, and it must be earned. And it is the choice of the choice of form is one that the court has consistently said, if an entity chooses a non-complying form, game over. You don't get the exemption. It's not, the word is incorporated, and the legislature plainly expressed their definition of a charitable organization. This relationship between LLC and elder trust, the LLCs are not corporations, and secondly, there is no formal declaration of trust.
Do you know how the application for exemption was prepared in the Children's Hospital case?
I do not.
Okay.
I'm afraid, I'm sorry, I do not.
Are the applications in the record?
Yes, they are.
The Children's Hospital applications or your applications? Or
The appellant's
appellant's
applications. And so when you look at when you step back and look at this, these towns are receiving these applications, which have very strict deadlines, and they are told the LLC is the charitable organization. The towns look at that, the Board of Assessors look at those applications, and LLC, it's not incorporated, it doesn't meet the bare statutory compliance. We are going to, we reject the exemption. It goes to the Appellate Tax Board. The Appellate Tax Board takes a look at the papers. It sees that the LLCs are the petitioners, the LLCs are the owners. It is represented on these forms that the owner of record is occupying. Now, on a couple of these Form ABCs, there is, on I believe, most of them, it just says the LLC's name. On a couple of them, it does have a handwritten notation and elder trust. But it does not negate the fact that elder trust is not the owner of the property. This is a two-tiered inquiry. Let's look at the bright line test thrown into the statute by the legislature. You take a look at those. Does the entity meet the bright line tests? Can we do the checklist? After we complete the checklist, then we go into the substantive inquiries, such as the dominant
All right,
purpose.
well, let's do the
test.
checklist then. This is real estate. Let's assume we conclude that it's held in trust for a charitable organization, and that as far as occupied, it's sufficiently occupied under the purposes of the statute to satisfy that requirement for real estate. So what else do we need?
Well, first we have to know who is the entity that occupies the property, is it a charitable organization? Because
Why?
why do we have to know that?
If we conclude that the occupation of the property is for charitable purposes, consistent with the mission of the charitable organization, Elder Trust, and we conclude that's sufficient occupation, are there any other tests?
I take it what you're saying, I take it, and I don't mean to answer the question posed by Justice Cordy, but I take it that you are looking at the "and occupied by it" language of the second clause of the second sort of big clause of Section 5(3), correct?
Yes.
So you're saying, if you are going to go that route, namely that this is real estate held in trust for a charitable organization, namely the Incorporated Elder, whatever it is, then it has to occupy.
Yes.
And you are saying, based on the filings with the town as to who the occupier is, the occupier are the three LLCs, not the it.
Exactly.
But on what, so the forms that are supposed to be filed are required where? In
They are
Section
required-
B?
If
Is that what you were saying?
Yes, they're in Chapter 59, Section 5, Clause 3rd, and then we go down to subsection B.
See, I don't understand that. It says a corporation coming within the foregoing description of a charitable organization or trust established, blah, blah, blah. That all relates to the first part of paragraph 3. This is neither of those, okay? Right? This is neither of those. There's just a disconnect between subparagraph B and the main paragraph 3rd.
A corporation coming within the foregoing description of a charitable organization. So if you're a charitable
Right,
organization
okay.
and you are a corporation, and then it goes on to talk about a declaration of trust. We have no formal declaration of trust in this case.
Right, doesn't qualify as that.
Okay, so we're talking about a corporation that is a charitable organization.
Mm-hmm.
Then you shall not be exempt for any year in which it omits to bring in to the assessors the list, statements, and affidavit required by Section 29. So if you go to 59, Section 29, it will spell out the Form ABC,
But this,
as they call it.
okay, but let's assume for a moment that you're correct that these LLCs are not charitable organizations.
By virtue of the fact that they are
They're not
incorporated.
corporations, but they are indeed, we conclude, the real estate they own is held in trust for a charitable organization, and they are the ones getting the tax exemption, correct?
And there's one more step.
Okay, and we conclude that it is sufficiently occupied for purposes of this provision.
And the key
Because-
is by whom?
Okay,
It has
but
to
if we
be-
assume they're sufficiently occupied by Elder Care Trust, then how does this little B apply?
Because if that is the case, then Elder Trust
Should be the
Should be the
filer.
applicant.
Should be the
should have
filer.
filed for the exemption.
Yeah.
There has to be transparency in the process.
But can,
But the Elder
protection
Trust,
of the
but
But-
the
but
tax
Elder
is to the
Trust-
LLC.
but I don't think I think Justice Cordy's point, and we'll have to, because the time is running, but am I correct that only a title owner can apply for an exemption?
No, it is, the exemption looks to who is occupying it, and it's, you put down the charitable organization, and then you represent who occupies the property. And so in their application, in the Form ABC, these entities always represented that the owner of the real estate occupied the property. There is no dispute in this case that the owners of these properties are the LLCs, not Elder Trust. Elder Trust is the sole member of the LLCs. They're a level removed.
So in order for this to have been an effective charitable exemption, you're saying that Elder Trust should have been the applicant.
I'm saying that assuming that you could establish that this was held in trust, they still can't make it. They still can't qualify for the exemption. And I do not concede the point that Elder Trust could.
But you are saying to me that somebody other than the title holder of the real property, seems a little odd to me, but nevertheless, the title holder, somebody other than the title holder to the real property which is being taxed can apply for an exemption.
I'm looking at the appendix for John Adams, and I'm looking at page 28, which I believe is the Form ABC. And the name...
Essentially, the beneficial owner of the property would be the applicant, and the person holding it in trust would be the person having legal title.
I'll back off that
Yes.
statement. Regardless of who the applicant is, who is represented as occupying that property is significant to the exemption.
It has to be the beneficial owner.
Yes.
It has to be the charitable organization,
Yeah.
For
qualified charitable
purposes of
organization,
of Section 5,
clause
A.
third.
yeah, A,
Right.
third, yes.
Okay,
Right.
so
I understand your argument.
okay.
Thank you,
Thank you
Ms.
so much
Carter.
for your patience. Thank you.